can also be restorative justice, where you are taken to at least to be seen, taken or to be seen, to be taken to where you were before. So it's called the restorative justice, among others that you can mention. Then after the sentencing, now you can choose the appeal process. So the next topic that we are doing is what we call the appeal. These are topics. Hizi topics inamalizwanga in 8 months. Kienda Kenya School of Law ni 8 months. Unazimaliza in within 2 hours. Appeals. So what are the grounds for appeals? Grounds for appeal. Number one ground, that the trial court erred. Yes, you can use erred or add or add. Make a mistake. Okay, the right thing is add. If you come from let me see. Add. You say add. Made a mistake. Number two ground, that the trial court did not follow the right procedure. So if you are an accused person, you appeal and you say that I had some witnesses which were not heard during the trial process. Therefore, I seek for retrial or revision so that this case should start afresh in the trial court. That is called the procedure. And in law, the Constitution says that procedural technicalities cannot override substantive justice. What we call the oxygen principle. Not carbon dioxide, oxygen principle. Don't say carbon dioxide, class. You will be suffocated. And that I think is in Article 159. Article 159 of the Constitution. The next one, that is under Article 159 of the Constitution. The next one is what we call the new evidence. That there is new evidence. That can be a ground. There can be many grounds. You can add other grounds. New evidence. Then what are the possible outcomes of the Court of Appeal? Number one outcome of the Court of Appeal is that the decision can be set aside. The decision can be verified. There can be a revision. You can get a retrial. Revision or a retrial. Or upheld. A decision can also be upheld. Decision of the lower court. So that is on appeals. Then class, now we go to another topic again. So this topic, we call it what we call it plea agreement. Plea agreement. Miguna will call it plea bargain. Can Miguna do these things? Eh? He's basking in the glory of his ignorance. Eh? Miguna cannot do these things. Once is he an advocate? One. Plea bargain or plea agreement. What we call what in layman's language we call the plea bargain. So the first, now in plea agreement, what is the normal procedure for plea agreement? There's a procedure that must follow. Number one, it may be initiated by the DPP or an accused person. May be initiated by the DPP or the accused person. Number two, that the agreement must be lodged in court. Lodging, still a lodging, lodging of the agreement in court. Number 3, that the court must mandatory shall not participate in plea agreement. By participate means that I could involved at the end wanna call the accused and the DPP or the victim or the complainant to agree on something. And number 4, that the nature of the case is considered. Nature of the case must be considered. And number 5, that the community interest must be considered. Community interest. Community interest must be considered. Community interest. Why? What am I saying by this? That if this person, if we get involved in a plea agreement, if it goes back to the community, of what consequence is it? Positive, negative, of what consequence is it? And that number 6, it's at the discretion of the court whether accept a plea agreement or not. The court may or may not agree. That the court's discretion. And why the plea agreement? Why the plea agreement? Why plea agreement? Why would an accused person want to be involved in plea agreement? What we call the purpose of the plea agreement. Number 1, that the accused person may want his case to be withdrawn. Withdrawal of the case. Number 2, that the accused person may want that a bigger charge, the weight of a bigger charge be reduced to a smaller charge. How do I put it? Larger charge, larger or huge charge or bigger charge. Bigger charge be reduced or substituted with a smaller one to smaller charge. Reduced or substituted with a smaller charge. And number 3, that an accused person may not want other charges to be incorporated or added to existing charge. Other charges not to be added to existing charges. Clearly, this is interesting. But you can clearly notice these things we are doing without reference, dispensing knowledge carelessly from the basket of knowledge, from the oracle, and knowledge is flowing from a region of high concentration to a region of, I don't want to say low, because these comrades are, their intelligence quotient is at optimum. Let's proceed. So that is about plea bargain, among other reasons, or plea agreement. Then the next thing, we're almost finishing class. Just give me another 10-15 minutes, we'll be done. The next topic is what we call private prosecution. Private prosecution. In private prosecution, what is private prosecution in the first place? This is where the DPP fails to do his work. Then a member of the public once goes to court, seeks the leave of court, leave his permission of court, and asks court that, you know what, the DPP has failed to charge this person. Therefore, I want this person charged and brought in court. So the court may grant leave or may not grant leave. That is under private prosecution. A good example is Koome, the former IG. If anybody wants to prosecute him, can be done. Any person in government, any citizen can be privately prosecuted. So the conditions for private prosecution is that number one, an offense must have been committed, or be seen to have been committed. Number two, that the DPP failed to discharge his duty of charging. And number three, that you must seek leave of court as a private citizen. Seek leave of court, permission of court to allow you to prosecute by use of a notice of motion. In a notice of motion, we are using a notice of motion. I'll teach you under civil litigation, where in a notice of motion, parties that we have, it is also here, parties that we have, number one is the applicant, and number two is the respondent. Then it starts as follows, that take notice that this honorable court shall be moved. Take notice that this honorable court shall be moved on dash day of August 2024. Where are you leaving dash for the court to fill? On dash day of August 2024 at 9 o'clock or soon thereafter, for the advocate for the accused or for the advocate for the applicant to be heard on the following orders. Order number one. This is the time that you clap, class. Order number one, that you certify the matter as urgent. Order number two, I'll get you that when we are doing extradition, where we use also a notice of motion. So I'm coming there, so suspend that just a little. Take leave of court. And number four, okay, up to there. And number four, that the decision, now the court may grant leave or not, that the decision of private prosecution is final. You cannot appeal the conviction, neither the sentencing. But in plea bargain, the previous topic that we've just done, you can never appeal on the conviction, but you can appeal on the sentencing. That's very clear. So you cannot appeal on the conviction, neither can you appeal on the sentencing. That is private prosecution. The next one is, we talk about extradition. Extradition. Unatoa mtu from one jurisdiction, one country to another jurisdiction. For example, somebody committed an offense in Uganda or in America and comes and hides in Kenya. So in extradition, the America as a country will ask Kenya. So America is called the requesting country and Kenya is called the extraditing country. To extradite the accused, the suspect, to their jurisdiction so that he can be tried there. Or you stole a chicken in Uganda, and Ugandans, the way they say that they supply us with eggs, they order for your extradition so that you be tried for stealing chicken in Uganda. So Museveni wants you to be taken to Uganda. So in extradition, there are conditions required for extradition process to take place. Condition number one, that there must be an extradition treaty. An extradition treaty that between the two countries, an extradition treaty between the two countries, that Kenya and America have a treaty on extradition. There must be. If there is none in one, then it cannot succeed. And number two, that the case that the accused is going to be tried on, the suspect, must not be a case that is political. Case must not be political in nature. Ruto anaweza sema tipelekeni huyu mtu huko huyu adiliwe nayo in another jurisdiction. Number three, the case of double criminality. Double criminality. Double criminality means that the case that you are being extradited for exists in the other jurisdiction in America or Uganda. Double criminality. That case exists in another jurisdiction. And number four, the case of speciality, the rule of speciality. Rule of speciality. That if you are going to be extradited from Kenya to US to answer on the charges that you committed, the offense, therefore the rule of speciality states clearly that you can only be tried on the same offense that you are arrested for, you are extradited for in Kenya. So if you did robbery with violence, you can only be tried for robbery with violence, not murder. And number five, that the fact that you've been arrested for extradition should not prejudice your case. The court should not be biased, should not prejudice your case. Should not be used. Should not, just that alone, let that country prove its case. Let the prosecution prove their case in that country. Next one. Documents used in extradition. Documents used in extradition. Now we have two types of documents. We have a country, you call it a requesting country. And we have an extraditing country. Now, a requesting country is a country that requests where you committed an offense. The first document they send to an extraditing country, US sending to Kenya, they send a document called a letter of request. Letter of request. They request, we request you to extradite so and so because he committed offense here in the United States of America. Number two, a charge sheet. Number three, what we call overseas warrant of arrest. Overseas warrant. Number four, what we call an authentication certificate. Hizi vitu vilikuwa zinafundishwa Teams University kweli. You can't teach these things in Teams University. That's a cyber cafe university. Okay? Authentication certificate to authenticate the above document. Then there's an extraditing country like Kenya telling US that, you know what, Kenya now having received all these documents that will go to the AG, the Attorney General, then the Attorney General will talk to the DPP, then the DPP will proceed to court. And if he proceeds to court, he will request the leave of court to proceed. At that particular moment, he will use a notice of motion. Number two, under certificate of urgency. supported by a supporting affidavit. You can add other documents if you know. Now, come back to notice of motion. So this is where I told you that I want us now to see how will the court be approached. The court will be approached by way of a notice of motion by the DPP. And the notice of motion, of course, you write the name of the court. Then after that, you write the parties. Then you write notice of motion. Then you start. Notice that this honorable court shall be moved on dash day of August 2024 at 9 o'clock in the forenoon or soon thereafter for the applicant, the person applying, for the advocate for the applicant, to be heard on the following orders. Order number 1, certify agent. Order number 2, you can request the court that a warrant of arrest be issued on the suspect, such that the suspect is arrested and put in custody. Order number 3, that the accused person or the suspect deposits his passport in court so that he cannot travel to any other country. And then you proceed by saying which application is premised or based on the following grounds. Ground number 1, you state the facts. What did this person do? Person X committed an offense in the United States of America, and this is what happened. This is what he did. Number 2, ground number 2, that there's an extraditing treaty between the two countries. Number 3, that the fact that we are extraditing this person will not be used against him or any other ground that you may deem fit. Then you proceed by saying which application shall be supported by an affidavit. Then you finish, you date it, you finish. Unaipeleka story imeisha hapo. Then you draft a supporting affidavit. That is extradition. That one will come even 20 marks. Where we? Be careful. These things are easy. So class, that is going to be, that is an examination topic. All these are examinable, but that can be very, very common. Question number 1 can be brought 20 marks. We have 2 more topics. Just be patient. The next topic that we can do is what we call the Habeas corpus. Habeas corpus. Habeas corpus application is an application that is made by an applicant through chamber summons. And the reason why it is made is that this person probably was arrested, by the police. We don't know where he is, or is in a police station somewhere. But the IG, the Inspector General of Police, has refused to produce this person in court. So therefore, you do an application for this person to be produced in court, whether dead or alive. It's called a habeas corpus. Produce the body. We want the body, dead or alive. So it is done by use of chamber summons. Chamber summons goes in the following way. Number 1, the court, as you draft it, you draft the court in the High Court. Then number 2, the parties involved. Then number 3, you just write chamber summons. Then it goes as follows. Let all parties concerned herein attend this honorable judge. Not honorable court. Honorable judge, because it is in the chambers. Let all parties concerned herein attend the honorable judge on dash day of August 2024 at 9 o'clock or soon thereafter for the applicant, for the advocate for the applicant to be heard on the following orders. Order number 1, certify as agent. Order number 2, that the Inspector General of Police be compelled to produce the suspect, so and so, to court. Which application, you can add other orders. Which application, or if the person is sick, you can give another order, that the IG be compelled to take that applicant, the suspect, to the hospital for treatment. Then you proceed. Which application is based on the following grounds, or premised on the following grounds? Ground number 1, that while the applicant, so and so, was going to meet his girlfriend, he was abducted on his way, or he had finished with his girlfriend and was still abducted on his way home. Second grounds you just narrate what happened. Then which application is further supported by an affidavit. Then you finish it. That is habeas corpus. Then the next one, the last one, is what we call the judicial review. Judicial. This is the last one, class. So just hang on my lips. Judicial review. Under judicial review, I just want you to know the grounds for judicial review. Judicial review is also done in civil litigation. I'll also talk about it after doing the criminal litigation. I will tell you it is done slightly different in criminal litigation and civil litigation. They are different. So grounds are the same. So the first ground is impartiality. Impartiality. Chukua dictionary. Second ground is unfairness. Unfairness. Third ground is ultra vires. Ultra vires acted outside their powers. Next ground is biasness. Next ground is unreasonableness. 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 Among other grounds. Then how do you approach the court? Judicial review means that, you know what, the DPP has decided to charge me wrongfully. Maybe ulimnyang'anya girlfriend, anakuchukia, sasa anasema tu wewe, I will deal with you. Analeta to charge from nowhere else. Anakucharge. That is what we call judicial review. Therefore, you move to court, to the High Court, using a petition in criminal litigation, constitutional petition. And you said clearly that I want to review the decision of the DPP, or the DCI decided to investigate you, and they should not investigate you. It is unlawful investigation. You go under judicial review for the judiciary to review in the High Court. Those are the grounds for the judicial review. In civil litigation, in judicial review, you approach it in 2 ways. Number 1, through the leave stage. In the leave stage, you ask the leave of the court. A situation, case in scenario, if you've been wrongfully impeached and you are a governor, because it is involving a quasi-body, a quasi-judicial body, quasi-judicial body, an administrative decision, not a judicial decision. For example, a student has been expelled from the university or suspended from the university, or you've been wrongfully dismissed at work. Those are wrongful dismissal. You go to court, you approach the court, you seek judicial review, and you seek leave of the court. How do you seek leave of the court? Number 1, you seek leave of the court by use of chamber summons. Number 2, by use of a certificate of urgency, because it is urgent. Number 3, a verifying affidavit. And number 4, by use of a statutory statement. Then after that, you go to the substantive stage. substantive stage, where you use a notice of motion and a supporting affidavit. That is civil litigation. Then some of the orders in civil litigation, we have prohibition, order of certiorari, and order of mandamus. Can either compel somebody to do something, or the court can compel somebody to stop something, or quash a decision. That is in civil litigation. I will also teach you that. I'm going to tell you the date. Then, oh, we finished. I think up to that level, class. Thank you very much. We've handled close to around between 13 to 15 topics today. I want to thank you very much. May God bless you all, class. We will proceed. I will communicate the next date. I will cover with you what we call I want to cover with you conveyancing. I want to cover with you civil litigation. I want to do with you professional ethics, trial advocacy. I want us to see probate and administration. We will do it. We'll do commercial transaction. We'll do LPM, which also involves accounting. I really love matters accounts and office work. Accounting, that is the easiest. That is where now ni kama kuweka chura kwa maji, because I really love playing around with the figures. So class, once again, I want to really thank you for listening, for concentrating in class. May God bless you and have a lovely night. Today, the 6th day of August. Najua tuko pamoja kabisa. God bless you all until we meet again. Asanteni.
Umeonaje? Umemaliza? Iko sawa? Ilikuwa